docket. That is case number 102-256, 102-257, State of Kansas v. Hilton.
May it please the Court, I'm Heather Cessna with the Appellate Defender Office here on behalf of Ms. Hilton, and I would like to request 4 minutes for rebuttal time, please.
4 minutes is granted.
Thank you. As the Court knows, we're here this evening to discuss the consecutive terms of probation that Ms. Hilton was assigned in this case. In particular importance is because the District Court not only ran her prison sentence consecutive under the special rule after she was revoked on her probation for a new crime, but also specifically the probation terms itself. And our argument is that there's legal consequence to that definition of consecutive, and that we disagree with the Court of Appeals' determination that the District Court has inherent authority to revoke a term of probation that has not yet begun. First off, I'm not going to go through, obviously, everything that we've written in our briefs. I know the Court's well prepared on those. Our main concern with the Court of Appeals' opinion in this case is that the idea that there is this inherent judicial authority to revoke on probation terms that have not yet begun, I think is problematic under the statutory language, which the Court of Appeals didn't really discuss, I think, adequately in its opinion. Specifically, what I wanted to draw the Court's attention to explicitly is that there are limits to the term of probation that the District Court is allowed to assign to a probationer without making special findings. And by essentially reading the Court of Appeals opinion the way they have, you're allowing the probationer on the second consecutive term of probation to essentially be serving a 24-month term instead of a 12-month term. And
only if you accept your premise that this case is so similar to Gary, it can't be distinguished. Isn't that right? Because Gary was a different situation. There hadn't been a sentence handed down yet.
And I can address that, Your Honor. I actually don't think that's as big of a difference as perhaps the state would like us to believe it is. I think the problem here is the use of the term consecutive. And I don't think that the state or the Court of Appeals in this case has put forth any particular reason, whether that's legislative or statutory or definitionally, why the term consecutive should mean anything different in the context of a non-prison sanction than it does in the context of a prison sanction. And in the context of a prison sanction, I think it's pretty clear that a consecutive term means that that sentence does not start until the previous sentence ends. And assuming for a moment, which I believe was the situation in this case, that even if the two probationary terms, which are consecutive to each other, have the same actual conditions of probation, where a violation during the first term would violate essentially the same conditions as the second term, you're still, because of the pronouncement of the District Court, have not begun that second term. And although I don't have a problem with a consideration of a previous violation during the first term in the context of the second term's probation violation, as far as whether or not to reinstate probation, I think the actual violation itself that causes the imposition of the actual prison sentence based on a violation that occurred prior to the term beginning is problematic.
Can we back up here?
Sure.
What specifically is the authority to enter into consecutive probation terms?
I'm glad you asked that question, Your Honor. This is actually one of the very few times I get to say that the state and I appear to be on the same side, and that we've both maintained throughout the appeal that there is statutory authority for consecutive terms of probation.
And where do you get that?
And I would draw your attention to a couple of statutes. And I will say right up front that this is not a situation where there's an explicit statute that says, yes, in this situation, there is statutory authority for consecutive terms of probation. But I think when you read a couple of these statutes together that I'll point out here in just a second, I think that you come to that conclusion. Specifically, I would draw the court's attention to 214720B, which is in terms of a multiple conviction case, which is not what we have here. But I think the statutory language is instructive. And that is, in that case, the legislature has explicitly said that it contemplated the possibility of consecutive terms of probation, and explicitly in subsection 8 of that statute said that that's not appropriate, that even if the prison terms are consecutive, that the probation terms cannot be. I think under the idea of the inclusion of one term versus the exclusion of another, that this court has to read that to say that the legislature knew that the consecutive terms of probation were a possibility, and that in certain situations they've determined that it's not appropriate. And because there's not explicit statutory authority preventing that, I think you can interpret, along with another statute, which I will point out, which is 214608A, that consecutive terms are possible. 4608A is the, A and C specifically, is the explicit statute that provides that when you commit a new crime while you're on probation, that those sentences have to run consecutive. And even though it talks generally about sentences and not specifically about prison versus non-prison terms, I think when you read the statutory language of subsection C, along with the fact that in previous, in other contexts, they have explicitly said no consecutive terms of probation, that since they did not provide that here, I think there is statutory authority to allow that in this case.
The reading between the lines situation, though.
It is, Your Honor. And I will admit, obviously it would be a lot nicer if the legislature had explicitly set this out. But I think they've made it clear that they knew it was a possibility and they have not otherwise accepted it.
I don't see anything clear in that whatsoever, Counselor. And what about the rule of lenity? If you're going to start implying things from statutory language, why don't you construe it in favor of the defendant? And I don't see consecutive sentencing as being in favor of the person impacted by the penal statute.
Well, I think under the rule of lenity, the benefit to having consecutive terms of probation is that if you get revoked, then potentially you're only getting revoked on one term and going to prison on one term instead of on both. In this case, it would have made a difference of 8 months in prison to Ms. Hilton. She would have only served 10 months instead of 18. So I think that even under the rule of lenity, it's still applicable as far as the benefit to the defendant in this case.
Under your interpretation of the statute, had she committed a new crime on that while on that first term of probation, she would have potentially been revoked and sent to prison for that, and the judge would have been mandated to make the prison term for that new crime consecutive. So she would be in prison for the first crime, conceivably. Then you would say she'd be on probation for a term? And then follow that by the new conviction and prison term?
I think, well, it would depend on if she got revoked on the second probation term then. But yes, I mean, I think that's the way that you have to read the statute if we're going down that road.
Is that a reasonable construction? I mean, if we look at the statutes, is that really what we can believe the legislature intended to have happen?
I suppose the answer to that question is that I think that the legislature is capable of explicitly setting out whether or not that is appropriate. And because they have not done so in this case, like I said, they could have accepted this and said we're not going to allow for consecutive terms of probation, and because they have not done so, I don't think it's this court's purpose to, as I think you've said in previous cases, darn the legislature's socks on that for them. I think that, and this kind of starts to morph into one of the other concerns that I wanted to bring up. I know the Court of Appeals talked a lot about the public policy concerns, and that was part of the reason why they had this inherent judicial authority to revoke on a term that's already been pronounced but is not yet technically begun to be served. And my response to that is that that's a valid concern. It's a valid concern for the legislature, though, and not for our courts. And certainly the legislature has proven in other situations that they are more than willing to come back and correct statutory language if they disagree or if they have these sorts of things pointed out to them that they did not intend. But we have to work with what we have. And while that may be a concern for the legislature, I don't think those public policy concerns should play into this court's interpretation of that statute.
Ms. Hessman, I want you to think about this a little more kind of on a cosmic level, if you will, and where inherent authority continues to exist, or common law authority continues to exist, and where it doesn't. Okay? So
Okay.
you're with me so far. So is the probation statutory scheme so complete that we can say that it has completely abrogated any pre-existing inherent power of the court or common law authority of the court? For example, like in a juvenile case, where we have precedent that says so comprehensively, basically it says, so comprehensively abrogates pre-existing authority of the court that we're going to say statutory authority is all that continues to exist.
I guess my answer to that would be, off the top of my head, I cannot think of anything in particular that stands out to me as not being complete. And I will say that obviously since this case has come down, there's been more and more amendments to the probationary terms. I mean, now there's a lot less judicial leeway that's given to how to impose probation and when and how it can be revoked. So I certainly think that we are farther along on that spectrum than perhaps we even were at the time that this case came about. But I can't think of anything off the top of my head that would prohibit that. Your Honor.
How does our recent case law pronouncements that the sentencing of a criminal defendant is strictly controlled by statute? We said that in Anthony and Mellors, or several cases, those specific words. And how do you strictly control sentencing with the statute while interjecting common law? Isn't that contradictory?
I think it is, Your Honor, and I think that's part of the reason why we had a problem with the Court of Appeals opinion in this case, and why our rationale here before this Court is so heavily dependent on what the statutory language does say. And as I said, even though it would obviously be a lot nicer if there was an explicit statement from the Court, I think that what we have is enough information statutorily that they knew that this was a possibility, that they could have prevented it, and they chose not to. And I think you have to assume that that was intentional. So I would agree with that, Your Honor.
More fundamentally, is that issue even before us? Or the issue of whether consecutive probation terms was...
You know, Your Honor, I kind of toyed back and forth with whether or not that was something to start off with, actually, up here this morning, or this evening, I should say. And the reason for that is because although the parties agreed to this sentence and have never challenged it as an illegal sentence, it seemed like from the Court of Appeals opinion, although they refused to address it on its merits, that there was a question raised as to whether or not this constituted an illegal sentence. And I suppose my fear here was that if this court determined that it was an illegal sentence, and obviously we don't get to the question of for the consecutive terms of probation to begin with. And obviously, even though this is pretty far into our appellate back and forth here, an illegal sentence can be corrected at any time, even at this stage at the Supreme Court. So I would say that I do think that it's probably something the court will need to address up front, although I think we've been on the same page and both have maintained throughout that it is statutorily provided for.
Counsel, I see you're out of time. Let me ask my colleagues if we have any further questions. Would you like 30 seconds to wrap up? Do you think you've made your points?
I mean, obviously this case has moved for my client. She's already served her time and is off paper at this point. But I think this is still instructive for the rest of the district court, so we appreciate you taking your time to address this issue. Thank you.
Thank you, counsel.
May it please the court, the appellant appears by Thomas J. Dries, duly elected and serving Ellis County Attorney. To answer some of those questions, it is the state's position that the defendant was on probation at the time in both cases. And the statutory language we rely upon, and I realize this differs somewhat from how the appellate court ruled, but if you look at the statute in existence at the time, 214602, now recodified at 216603, with the same language in subsection C, probation is a procedure under which a defendant found guilty of a crime is released by the court after imposition of sentence, without imprisonment, subject to conditions imposed by the court. And I believe that's the situation Ms. Hilton was in. She had been convicted, sentenced. The court had pronounced she was going on probation. The court ordered it consecutive, and the court set limitations and ordered her to community corrections supervision.
But the court did not order 24 months concurrent probation, which is what you're arguing was de facto what was happening.
The court ordered, if you look at the sentencing journal entry, 12 plus 12.
It says
20
probation of 12
24
months
months.
consecutive to the probation of 12 months in 05 CR 264 revoked and reinstated. Total of
Exactly.
24 months probation to begin today.
Exactly. And I think you have to couple that with,
Well, let me ask you this. If that were 2 prison terms of 12 months consecutive to 12 months, would the defendant be serving both sentences from the beginning?
yes, those sentences aggregate. You've got the first sentence, you've got the second sentence, and they're aggregate, and they're hooked together. And as they serve that first sentence, it falls off, and then they serve the second sentence. But when it begins, those boxcard or consecutive sentences are hooked together. And it is our position it's the same thing with probation. And I believe the statutory authority for that is under 214610, now codified at 216607, that under subsection A, nothing in this section shall be construed to limit the authority of the court to impose or modify any general or specific conditions of probation. And then you couple that with subsection C. The court may impose any condition of probation, skipping some words, that the court deems proper. I think in this day and age, when the legislature has continually taken power away from judges, when you look at the language that it deals with for probation, it has specifically left it very broad and very open, for the reason that probation is a situation where you have to let judges be judges. You have to give that sentencing judge the authority to impose what conditions that judge believes is appropriate to keep the community safe and to ensure that the defendant has the best shot at rehabilitation offered by the system.
That sounds like a great argument to make to the legislature. Really, I mean, if criminal sentencing is controlled by statute, then, and the statutes aren't appropriate to protect the public, why isn't it the legislature's responsibility to get that fixed rather than us coming up with a public policy inherent power that's not specified in the statute?
Well, I don't think it needs a fix. I agree with the common law concept that it is an inherent power of probation. But I think when you look at how broad that statute is written, about nothing shall be construed to limit the authority of the court to impose or modify general or specific conditions of probations, and that the court may impose any condition of probation that the court deems proper. I think that gives the court the authority to do what has been recognized for centuries, and that is consecutive sentences, which would then also give them the authority to impose consecutive probations.
Would you agree that the court here did not have any authority to modify the duration of the second sentence, even though it was 8 months on the first and 12 months on the second? If he hadn't started serving that second sentence, there was no means by which the court could modify that sentence, could it?
I don't think that, with all due respect, Judge Johnson, I don't think that's the status of the law at all. I think if you look at what is now codified at 216608, under subsection 5, it says, if the court finds and sets forth with particularity the reasons for finding that the safety of the members of the public will be jeopardized, or that the welfare of the inmate will not be served by the length of probation term provided in subsection C3 and 4, which sets out whether it's 12, 18, or 36 months on a felony. The court may impose a longer period of probation. Such an increase shall not be considered a departure and shall not be subject to appeal. So
But-
I think
but
that
that's
gives
in
the
the
judge
beginning.
the authority to do
That's in the
that.
beginning. In the beginning, when he made the initial sentencing, he could have made it 18 months instead of 12 months on the second. But we have a specific statute that says once you pronounce that sentence, you can't modify it. You're saying that that provision for initial sentencing also gives the right to modify at any time without revocation?
I think that setting forth the actual terms of probation that 216608 does, that is at the beginning, and that gives the judge the authority to set forth a greater period of time than is what is suggested. I think it's important to remember these are sentencing guidelines for the judge. But they have built in them power and authority for the court to use its discretion to do what is right for the community and for the probationer. And I
So-
think that statute clearly gives the judge the authority to increase it at the beginning when sentencing, or at any time that you're back in front of the court on a motion to modify or revoke probation.
Are you suggesting that at a sentencing, you can impose a prison sentence, and if that prison sentence calls for a 12-month supervised probation, that the court then could order an 18-month
Yes,
supervised beyond what the statute allows?
because of that subsection 5, it says if the court sets forth with particularity the reasons, the court can extend that probation, and it is not subject to appeal. It's not a departure from our guidelines. That is the authority the court has in the beginning.
Are you saying that although the court used the word consecutive here, what the court really did was impose two 24-month concurrent sentences?
No, not at all. Not at all. Judge Tepfer specifically chose to impose 2 consecutive sentences. And Judge Tepfer is deceased. He'll be gone now 3 years come April 30th. He was a very strong believer in community corrections, a very strong believer in giving people a chance on probation. By putting those consecutive, had she successfully served that first year of probation, the half of her sentence would have fallen off. She would no longer been subject to being revoked for the entire sentence. That gave her incentive to do well the first year so that that first sentence falls off, leaving only the second sentence, which I believe he had the authority under statute to do. Now, I agree, for the first year, they're aggregate. She is serving both. And what it really does is it imposes an aggregate sentence for the second probation. The second one, in effect, becomes 24 because it's been boxcarred. So when the first one falls off, then you have the next 12 months. But I think he did that intentionally to give her a chance to get that first sentence taken off at the end of 1 year.
Well-
She would no longer be facing that first sentence.
I don't know if
we
that's
can
the
read I don't think we can read anything into what intentionally happened, because initially he imposed concurrent probations and then was corrected by both the defendant and the state to impose consecutive. I don't know if this was any kind of plan on the judge's part in that way. He adopted the recommendations of both the defendant and the
Well-
state, isn't that right? I mean, that's what I read.
And again, on a cold transcript, I think that is a way you could interpret that, but it can also be interpreted that he was going through, we were doing the plea, we were talking about it, it was at the very end, and he said concurrent rather than consecutive, and he was corrected by defense counsel, and he said consecutive.
Let me make certain I understand your argument that it was an aggregate probation of 24 months, and for the, or
For
total,
the second
total,
sentence.
total of 24 months, and that the first 12 months, the defendant was serving both probations, And then at
Boxcar.
the end of 24 months, she began serving only the second probation.
At the end of 12.
12 months, yeah.
At the end of 12, the first sentence fell off. The 05 case would have been gone had she been successful. Then at the end of 12 months, she would just have the second case probation and the second sentence hanging over her head. That's what she bargained for in the plea. That's what the court had agreed to do, and I think the authority in the statute is there to do that.
And that authority is that the court could have imposed a 24-month initial probation.
The court could have imposed 24 on either one of these cases. Certainly, with her record, he could have looked at the record and her long history of convictions and said, you need a much longer period of time. The
And
court was well within its rights to give her 24 on each.
But you get there from the pronouncement after 12 months consecutive to probation of 12 months, the statement that it's a total of 24 months probation to begin today.
Yes.
And you're saying that that means that it was imposed, it aggregated for the first 12 months. You get that out of that language.
That is the position we argued in our initial brief before the appellate court. The appellate court really didn't address that because it said it didn't have to, although Judge Atchison, in his concurring opinion, clearly stated that that is something that had to be considered. In his concurring opinion, he stressed a strong, at least it seemed to me, a strong displeasure for the idea of consecutive sentences, consecutive probations.
I
But,
think he calls them dubious. that
right,
that's
so
dubious.
we're in a situation where I think the appellate court was right. I think the court does have the inherent power that a judge has when they impose probation. And per statute, as soon as the court pronounced that sentence, that put her under supervision, and that put her under the court's continuing jurisdiction. I don't think it's appropriate to try to read this to say that the first sentence was just held in abeyance. There's nothing in the statute that gives the authority just to hold that first sentence in abeyance. But once it was pronounced by the court at the sentencing, it became effective per the statute. And then the second statute says the court has broad range, broad power. And the court has said that. The court has said that in other cases, as was cited in our brief, under the Carr case, not the most recent, but the 2002 Carr case, and also the Bennett case in 2008, that probation is an alternative to serving a prison sentence, and probation conditions are not presumptive. They are within the discretion of the sentencing court. And that was State versus Spencer, 31 Kansas Appellate 2nd, 681 in 2003, and also the Bennett case, 39 Can App 2nd, 890, 2008 at 891, where the court acknowledged that the sentencing judge still has a lot of authority and discretion in probation. And as I started with, I think given the current climate, given what the legislature has done with sentencing, the fact that they have left probation that broad and that wide open for the sentencing judge was done intentionally.
Counsel, if there are two prison sentences that are ordered to be run consecutive, is the second one being held in abeyance during service of the first?
No, I think they start like this. When you have if you have a 10-year sentence and a 5-year sentence consecutive, you got 15 years. Now, when the first one is served, it falls off, and then you have that last 5 one. But at the beginning, they are hooked. Common parlance in the legal business of boxcarring these. These are hooked together. They start out together, and then the first one upon service falls off, leaving the second one.
Factual question. Were there two written orders of probation or two orders of probation signed by this defendant, or just one?
That would be up to Community Corrections. I don't know, Justice
don't know.
Johnson.
Okay.
She was ordered to Community Corrections, and I don't know if she signed one or two separate documents for corrections.
And the state moved to revoke both probations.
Yes,
in both cases? So
Yes.
it was essentially a joint hearing on two case numbers?
We did have a joint hearing on both cases. And her counsel at the time argued the same argument that you can't revoke both because she's not on. And Judge Tepford clearly, in his ruling at the revocation hearing, said, yes, she was on both, and she's being revoked on both, which I think also gives us a good idea of what he intended at the time of sentencing, because remember, the revocation hearing was only 2 months later. She was sentenced on January 9th, and we were back in there March 12th for the revocation.
Counsel, you're out of time. I'm going to ask my colleagues if we have any further questions. Would you like 30 seconds to wrap up, or do you think you've made your points?
I think I've made my point, Your Honor.
All right, thank you, counsel.
Thank you.
You reserve 4 minutes for rebuttal.
Just to address counsel's argument, the state relies heavily on the idea that there's some statutory language that talks about a broad discretion to modify conditions of probation. And I just want to point out that to the extent that that statute does say that, it's explicit to the conditions of probation, which is different from the term of probation. And that's fundamentally what we have a problem with here, is that in order for that second consecutive term to be revoked, at the time that they revoked it, it would have needed the district court to make explicit statutory findings to extend that to a 24-month probation, which did not happen in this case. And so to the extent that they rely on that statutory language, I don't think it's very helpful. And last but not least, I think one of the points that we wanted to make is that there's this idea here that there's no statutory, or the state has made the argument that there's no explicit statutory language to hold the condition of probation in abeyance. And I would submit that there is, and it's the term consecutive. That's what that means. And again, I go back to what I started off with here tonight, which is I don't understand why we would read this differently in the context of a non-prison sanction versus a prison sanction. And I think that the case law has been very explicit as to what a consecutive prison term means. And I have no reason to think that there's any difference here for a non-prison sanction, especially under the statutory language.
How do you address counsel's argument that even in a prison sanction, that when you aggregate, you're serving both sentences from day one?
I think that's wrong. I think that this court has explicitly come out and said that the two terms of prison are separate. And I don't think that you can, even if they're run back to back, they are not being served at the same time. And I think there's plenty of case law to support that. And other than that, I didn't have any additional comments. Thank you.
Any more questions of counsel? I see none. Thank you, counsel. We thank you both for your arguments tonight. And the court will not rule from the bench, but we will take this case under advisement. Thank you.